Mr. Sims.
Good afternoon, my lords and ladies. I probably should give you an idea of where I'm going. I was going to make some initial observations and in the course of doing so, obviously my first observation I got a little bit sidetracked. But what I propose to do is just give you some headings, and I may spend more or less time on those depending on what the Tribunal is interested in hearing from us on. The first heading was to make some introductory observations, in particular looking at the specific sections within the Act itself, and asking us what is the key interpretation question for us. The second is looking at some of the history of the legislative scheme and some of the case law, because we say that sheds some light on what Section 39.3 now says, in particular looking at Section 44 of the Financial Services Act 1986 and the history behind that. And the third heading we then had was looking at the decisions in the courts below and the reasons why we, in effect, invite you to conclude that they were right to reject the defence in effect relied on by Malone and Friend on this appeal. And then probably the final section then is dealing with questions arising in relation to absurdity, which we say arises on Malone and Friend's construction in terms of the consequences and the lack of coherence that we end up with if they are right in relation to their submissions, which of course is relevant to the question of statutory interpretation before you. So those are the brief headings. I'm going to give my learned junior the opportunity to address you on some of the absurdity points. I may well address some of them as I go along in any event, because it will pick up a few of them as we go along, but I'm intending to give him, roughly speaking, 20 or 30 minutes.
Mr. Sims, I'm struggling to hear you.
Sorry. I'm going to give him 20 or 30 minutes so that we can give him the opportunity to address you on that topic. So that's my route map. So far as the starting point then, my overview submissions in relation to the central question on the appeal, and it's worth, I think, having just open in front of us section 39, which is at page 911. And the focus for the purposes of the argument starts in section 39.1. Of course, that is obviously then linked with subsection 3 at page 913. But starting with subsection 1, the key words for the purposes we're focusing on are if a person other than an authorised person is a party to a contract with an authorised person, i.e. his principal, which I permits or requires him to carry on business of a prescribed description, and 2 complies with such requirements as may be prescribed, and B is someone for whose activities in carrying on the whole or part of that business his principal has accepted responsibility in writing. So the key words for the purposes of this appeal are the words business of a prescribed description, and in particular activities in the carrying on the whole or part of the business of a prescribed description. That is the gateway chosen by Parliament to confer exemption, and with it statutory responsibility. And that incorporates the prescribed description set out in the Regulated Activities Order, which is to be found at page 968, and we've just included the particular provisions here, which are the specified activities in question.
I thought the reference to prescribed description there was said to be
prescribed in the appointed representative?
Yeah, sorry, I skipped. Yes, sorry, you're quite right. It goes to Regulation 2 first and then on to that. Yes, you're quite right. I skipped. So we should go first to page 974, Regulation 2. I'm grateful. And you can see that that's at page 974. We then have the descriptions of the business which the appointed representatives are exempt, and we then see the various activities of the kind specified in the RAO. My apologies, I jumped to the RAO. And you can then see...
So it's not every activity in the regulated order that can become a permitted...
Prescribed
for an appointed representative.
The specific ones identified. And in particular, the ones that are relevant for the purposes of this appeal are the reference to Article 25, which you see in 1A, an activity of the kind specified by Article 25, which is arranging deals in investments. And then you need to go to page 975 to see the definition of activity in relation to advising on investments by reference to Article 53.
So page 9.
Page 975.
975, right.
So subparagraph C?
Subparagraph C, yeah. So those are the two specific parts of the appointed representatives regulations, which then take you into the specified activities by further reference to what is contained in the regulated activities order, which if we go back to the provision I took you to a few moments ago, for example, that starts at page 968, but we just included the relevant ones here. Article 25, arranging deals in investments.
So what would happen if you purported to appoint an appointed representative to carry out an activity which was a regulated activity but which is not in the list in Regulation 2, and they did that?
They're not entitled to do that.
But they wouldn't get the exemption, would they, under Section 39?
There wouldn't be any exemption.
No. Because,
Yeah.
To get the exemption under Section 39, it needs to be a prescribed business.
Exactly. So it is only in relation to regulated activities, and more particularly those that are prescribed as laid down in Regulation 2, as you've identified, which then takes you into the gateways.
Right, but the principal wouldn't be liable in those circumstances then?
No. You have to get through those gateways. So the fundamental building block for all of this is a contractual recognition within a contract between the AR and the AEP that by reference to these activities, or part thereof, we'll come back to part thereof in a few moments' time, but by reference to these activities, we are permitting or requiring you to do these specific activities. And this is a fundamental point to understand so far as the construction of Section 39, 1 and 3 is concerned, because it's looking at the kind of activities, the type of activities, without reference to customer types or customer classification. You don't see that concept in any of the provisions that I've just taken you to. In fact, if you look at the provisions, they just talk about a person.
So which provisions are we talking about?
So, for example, if we look at
Paragraph 25, is it?
25, for example, yes.
Yeah.
Article 25.
It's on page 968.
968, yes. So our simple point is this. that you do not get any steer or indication from the words of the statute that Parliament intended that you could cut down the prescribed activities by reference to which you're responsible for, by reference to client classification or customer type.
Sorry, by reference
By reference to client classification or customer type.
I mean, I appreciate it's the words that we're going to be debating, but it might be said that all part of that business does that work.
So that's what I'm going to come on to. The question then arises, what are the limits for part of the business?
Yeah.
And it's accepted on the one hand that part of that business cannot be read literally as everything. Because
Sorry, cannot be read
cannot
literally.
be read literally as everything.
Right.
Because you could constrain the part of the business by saying, I'm going to be only responsible in circumstances where, for example, you assess someone as suitable.
Assess someone?
Assess someone as suitable.
When do you assess someone as suitable?
Under the COBS regime, for example, you would ask whether someone is suitable to advise or sell a particular type of investment under the COBS 9 regime. So you can define...
I'm sorry, I'm getting a bit lost. You assess someone whether they are suitable to sell.
It was the product that had to be suitable for the client.
Yes. Not right.
Yes, sorry.
So you're not
So,
assessing the
I
individual.
don't think it matters for present purposes.
Well, I think it does. Sorry. So what you're talking about is, just to be clear,
Yeah.
assessing the suitability of a product or investment, are you, in that example? I mean, I'm not aware of any provision that talks about assessing the suitability of a person. That's why I picked you up
product
on
for
it.
that person.
Right, that's it.
For that
Right,
person.
right.
Yes. Sorry, perhaps I misspoke. So let's just take the simple point I'm making is this: is that it's accepted there are limits.
But I'm not sure that I understand that, because, I mean, surely getting it wrong in your assessment of whether a product is suitable isn't a different type of business. I mean, it's not part of a business to get it wrong and part of a business to get it right. I mean, they're not separate businesses or separate parts of a business, are they?
Well, in the same way, we would respectfully suggest that it's not part of a business to be talking about carving out a particular type of client.
Why not?
Because in relation to clients, every type of business activity is going to involve an assessment of the client and the question of...
But I mean, at a very basic level, is there not a difference between a retail business and a wholesale business?
Only in the sense that you could capture those different categories by reference to a process after you've carried out the question of how they're to be assessed in terms of client classification.
I was perhaps taking a slightly
Yes.
broader look. I mean, but as I say, in a general, I mean, I don't quite see how, as a matter of language, you could ever say that carrying on a business competently is a different part of a business than carrying it on negligently.
Well,
you're carrying on the business either competently or negligently.
Well, in this,
but
I don't disagree with that proposition.
But equally, could you not say that a retail business is different from a wholesale business?
I don't think you could when you examine that question by reference to
in a general sense.
What Parliament intended by reference.
Well, I understand that. So
yes.
I mean, but in a very general sense, would you accept that that Marks and Spencer's carries on a retail business and other companies carrying on wholesale businesses, and they're not the same type of business?
In relation to retail and wholesale, of course, you have those categorisations. I don't balk at that idea.
Right.
You have those categorisations. Okay. I think that the more...
You say in the context here, that's not a categorisation that you can validly make.
Exactly. In the context here, where legislature chose that this would be by reference to certain prescribed activities, and those activities are by reference to, in particular, these generic categories, where you could very easily, if you'd intended to have a separate regime which split out, we'll come back to the question of whether or not retail and elected professionals actually existed as at the date in question we're dealing with. But assuming for present purposes there was that division in customer classification as at that time, why didn't Parliament, if that was intended to be a restriction or a limitation which was valid, do you see that in the primary legislation, or indeed the RAO? But
might it not be said that, looking at section 39(1)(b) on page 911, what Parliament is contemplating is that a business may be carved up in lots of different ways? So, I mean, in response to the point that you're making, might it not be said, well, why single out retail against wholesale? That's just one way in which a business can be carved up. It can be carved up in lots of other ways, and this seems to be a general authorisation to the AP to, when making the arrangements with the AR, to carve up the business in all sorts of ways, depending on what seems good to the AP.
But what we would say is that the only way that it's contemplated it could legitimately be carved up is if you can do that in such a way that you're not adding additional language, if you like, to the descriptions of the activities as a matter of the way that they function. So to take this example, going back to Anderson and Sens, the position in Anderson and Sens was that a particular type of business could readily be identified and demarcated by reference to the company agency, which was clear and simple. And in that context, you can understand how you might properly say that that is part, functionally, of the business which is defined by reference to business of a prescribed description of advising or arranging investments in relation to the particular investments in question. But
so is that then the test then, whether it's... I thought you were saying that the test is it's got to be indicated somehow in Regulation 2 that this is a division of that kind of activity that's listed that is envisaged within Regulation 2, but now, because you have to accept Anderson is a correct result, or you do accept that, now are you changing that to say, or if it's not something that seems to be expressly contemplated within Regulation 2 of the appointed representative regulations, it's got to be an easily carried out something else division of the part? Is that...
Yes, there has to be a clear and easy way for that business. A clear demarcation, I think, was the word used by Lord Justice Mayles in the Court of Appeal, which we would agree with. There has to be a clear demarcation line. Otherwise, you end up with a test which involves, and client classification is a good example of this, in effect a trial on the issue of whether or not a client has been properly classified.
So the other thing that they were not allowed to do was deal with US residents. So would you say that that is something for which the principal here, Kession, would not be liable under sections 39(3), or do you say that they would be liable if JHM had sold to US residents?
On our primary formulation, under just taking ourselves through to Regulation 2, it would not. The question would then arise, on the alternative way of putting it,
It would not what? Sorry. Which way are you going?
the concept of a US citizen distinction is not there. You don't see it
Right.
within the prescribed description of categories. So far as the question of whether or not that would then be something which would be easy to determine or not, that might give rise to some factual questions, I suppose, as to whether or not someone is so properly characterised as not.
But for any legal line that you draw, there can be factual issues that arise. It's just whether they're very wide factual issues or quite narrow.
But I think the particular difficulty which gives rise to the suggestion that you can, in effect, treat retail and non-retail as these neat categories which you can say they are the principal can say they're not responsible for, is that is an evaluative exercise which is carried out and this is a point which I'll briefly go to. Melania Junior will develop a bit more detail. It's an evaluative exercise which is a question of a judgment call, which not only has a lot in common with the question of the suitability test criteria, but actually bleeds into the suitability test criteria. But for the purposes of assessing suitability for clients who elect up to become professional clients, you have a situation where part of the assessment of suitability is governed by an assumption that because you've treated them as an elected professional, they can be treated as assumed to have a certain amount of knowledge and experience.
But I'm sorry, I think that the suitability of an investment point is dictated by, isn't it, whether they're a professional or retail client? So you first of all, don't you determine, is this person let's go for sake of convenience, call them professional clients, is this person a professional client? If so, then sort of certain suitability criteria may apply. If not, if they're a retail client, then a different approach is required.
Well, no, that's not, in fact, that clear dividing line.
I see.
That if we just go to Cobb's 9, because this is a point I think Malone Friend sought to make, which with respect we disagree with him.
Just before you, I'm so sorry, and it is my fault. I didn't note down your answer to Lady Rose's question about the US citizens. I understood you to say, look at Regulation 2 on page 974. Yes. You don't see US citizens listed there. No, you
don't. And I suppose my primary answer would be to that is there any indication in the language, either in section 39.1 or any of the associated provisions, that Parliament intended that could be cut down? I'm not aware of any, and
so your answer is that you could not cut out.
If, for example, you mistakenly thought someone should be treated as a UK citizen rather than US citizen, that potentially, in our case, yes, would.
Look,
because
no, you're confusing two things there. There's the question of whether it's possible to exclude someone who is a US, whether it's possible to limit the permission granted to the appointed representative so as not to exclude US residents, right? And that is a question for everybody, right? Can you draw that? Is that a distinction that you can make in your agreement, right? And if you say, no, it isn't, then even if somebody lives all their life in New York and never sets foot out of New York State, you still would be stuck with responsibility for them because you haven't excluded part of the business. Or are you saying, yes, you can exclude that part of the business, but you couldn't exclude it if this was an actual person who lives part of the time in New York, part of the time in London? I mean, those are two different things.
Yes. Well, I don't think it's necessary for our appeal for us to push the boundaries on the
well, it's necessary for us to find what principle we're applying here.
Yes, no, I understand that. And I think on my lady's categorisation, it would probably be the second rather than the first, in the sense that we
I didn't understand. I think my lady was drawing a distinction between you can ask the question at the level of principle or you can ask it in individual cases. My understanding was my lady was asking it, first of all, at the level of principle. Suppose the ARA says you shall not deal with people who are US citizens, as indeed this one did say.
Yes.
Does that create an exemption?
Insofar as the question of, not obviously they can as a matter of contract, but the question is not as a matter of contract. The question is as a matter of, for the purposes of carving out of their assumption of responsibility, for the purposes of section 39.91, and 3 by reference as exemption as well.
Right.
In relation to that category of person, so far as the US citizen approach is concerned, there is no demarcation of those particular people by reference to the prescribed activities in Regulation 2.
But the question still stands.
And so therefore, on the basis of that basis, that you if you wrongly entered into that sphere of work, then you would, on our primary case, be
right. So your primary case is yes, you can create the exemption by.
No.
The exemption covers.
An exemption, but you can't exclude.
Yes.
Selling to US resident citizens, I think the expression is not part of a business for these purposes.
You could say,
which is it? Sorry, which can you just answer which it is?
No. The point that I was making is that we, for the purposes of our submission, say you look at the description of activity by reference to arranging deals or advising in investments, not by reference to customer type or customer description.
That's your Regulation 2 point.
Yes, our Regulation 2 point. So if it said, well, I'm moving on to a secondary line of reasoning, which is that, and then I get onto our clear demarcation argument.
So is this right? On your primary case, where demarcation on your primary case has to follow the Regulation 2 demarcations, is that right? If you had written into the ARA, you shall not deal with US citizens across the board, that would not qualify as identifying part of that business.
Because functionally it doesn't form any part of the definition of the prescribed activities of arranging deals in investments or advising on investments.
Right. So I think your answer to my question is yes. It would you could not use that to say yes, that's part of the business.
Exactly. That's
right.
And the reason.
Okay, that's clear. Speaking for myself, I understand that submission. You had an alternative submission. Can you just explain that?
So the alternative submission was the concept of clear demarcation, and in Anse and in Sense, of course. There could be a very clear demarcation which involved no judgment calls, which is the question of, is there a company agency or not? There's a list, and in effect, it's a yes or no simple answer. But in the context of client categorization, there aren't. It's an evaluative exercise which involves subjective calls as regards knowledge and experience of individuals, which has to be carried out in relation to every single client on an onboarding process, and which feeds in.
And I think my simple question on your alternative is, take the example of US citizens excluded. Is that a clear demarcation according to this criterion or not, according to you?
Well, not citizens. I think it's residents.
All right. Sorry.
It's actually resident citizens.
All right. Resident citizens. Anyway, take the category resident citizens.
I can see a scenario where that might be a more straightforward test to apply. It depends on whether you get into arguments about what sometimes one sees in the insolvency context of Comey type arguments about.
Well, you get it in tax.
Yes.
Quite a lot of tax cases are about whether someone is resident in the UK or whatever.
But I'm not. I think we need to sort of come back to the question of here, what we're really focused on here is the regulatory perimeter in this jurisdiction. So
The what?
regulatory perimeter in this jurisdiction. So this is a statute which is intended to deal with the regulatory perimeter in this jurisdiction. I'm not aware of I think the reason why you might have the US citizen category is because, as a matter of practice, lots of ARs and authorised persons just can't get insurance for that for US citizen category work, and so therefore they just vis-a-vis their AR, they just have a blanket prohibition on that.
Do you accept that on your first, what you've called your primary case, which is that you've got to look at how things are divided up in Regulation 2 of the appointed representative regulations, that then Anderson must have come to the wrong result?
Well, in Anderson's sense, you can see how the words part of work more effectively in that context, in the sense that the part of you're seeking to deal there is by reference to a specific part of the type of activity in relation to the investments, which you get as a sort of a clear linkage back to the statutory wording. I don't know if I've put that very clearly, but you're with the Anderson type case, you have the situation where you have your specified activity by reference to whether it's, let's say, advising or arranging in relation to certain investments. And then you can clearly see within a subdivision of those types of investments, conceptually, you could say that companies which have agency X are a part of that investment business, in the sense that you can conceptually see that as a subdivision of a type of investment within which you are dealing with.
It doesn't say anything about company agencies.
No, but as a matter of, how shall I put it, defining the functional field for which an AR the authorised person is agreeing to be responsible for, you can see an argument for saying that you can give meaningful effect to the words part of in that context by reference to simply a specific product, let's say life investments with...
So although investments is a term of art in the regime, isn't it? I think
the investments obviously have various then subcategories, and yes, it's a term of art which then takes you to a list of investments.
Yeah.
And those list of investments then include obviously things like securities.
Yeah, but they don't include securities as long as you do them through a company agency.
No, they don't contain those specific words, but you can see at a functional level how that might operate, in the sense that in that context there is a ready and easy clear demarcation between the 2 points. So the way I might try to describe it is that if you imagine the field of activity which you're dealing with is advising or arranging deals in investments, that is within the definition. Investments as a concept is within the definition. But by reference to customer X or Y is not within the definition. And so that's why we say we come back to the question of how do you reconcile that with Anderson's sense?
Well, would it help in that respect if you took us, and I'm just quickly trying to search through the judgment in Anderson, as to how in the judgment there I did apply that exercise with which my brother in the Court of Appeal agreed? What was the process of reasoning in Anderson whereby it was said that the exclusion of certain products products meant that you had a permission for part of the business. In other words, you could divide the business up into different parts by reference to different products. So what was the process of reasoning by which that result was reached in Anderson?
Let's just briefly turn up Anderson in the Court of Appeal, and it starts at 374 in the bundle. And so far as the issues on appeal were concerned, they start in paragraph 22. Liability under section 39 starts at paragraph 23. And the reasoning of my Lord, as he then was, Lord Justice Dave Richards, starts at paragraph 29.
I mean, I just quickly looking through it, I thought that the closing two sentences, I think, of paragraph 32 were in point, and then I think it's picked up again in possibly in paragraph 37 and may go on a bit after that.
So as far as the point in paragraph 32 is it need not relate to all activity that could fall within a generic type of business. Then that still gives rise to the question of how you define what part of it meant.
Yes, exactly.
And I think for the purposes of the particular passage where you deal with the position in relation to company agencies, that in particular is then, I think, well, we obviously have the what and the how discussion in.
Well, I think isn't paragraph 37 in point? I mean, because I addressed the submission that you made as to what the whole or part was, and I think if you pick it up at letter D on page 384.
So I think. So
I say there the purpose of section 39(1) is to confer exempt status on persons in a manner which will fulfil the underlying regulatory and protective purposes.
Exactly.
It may make perfect sense to limit an AR to a partial exemption having regard to the breadth and depth of the expertise of that AR, or indeed of the authorised person.
Yes. But
so that's not linked to products.
Well,
I haven't looked right the way through.
I think it was linked to the idea that if you could tie the acceptance of responsibility by reference to a certain specific list of company agencies, that would aid in the ability of the.
But here, if I may say so, this is a general point being made. And I mean, I don't want either to construe my words, Lords, as though they're a statute or to put words in his mouth, but just reading that, you can have a partial exemption having regard to the breadth and depth of the expertise of the AR or indeed of the authorised person. That seems, to my mind, to go back to the point, well, people may be experienced and expert in dealing with retail customers or not. They may be experienced in dealing with non-retail customers. So, I mean, if one were just reading these words, that seems to have a tendency against your proposed categorisation, which would exclude those ways of carving up the business.
Well, certainly for the purposes of asking ourselves the central question in terms of how one could reconcile what we're submitting with Anderson Sense in terms of the company agency position, the way that we rationalise it is because when you seek to identify as a subcategory of investment, you can see how you can do that by reference to particular type of investments. I accept that you might read passages in Anderson Sense as supporting a proposition to go wider than that. But on the facts of that case, the true ratio in Anderson's sense was restricted to the company agency point, and that can be functionally rationalised by reference to a subdivision, if I can put it that way, of investments which do form part of the statutory definition. In the same way, you can't say the same can't say the same thing in the same way vis-à-vis seeking to say part of that business is defined by reference to client classification. I think that's where we...
But again, if I'm allowed to pick up my Lord's words in paragraph 37, the overarching idea is that one should construe section 39(1) in line with the purpose of the legislative regime. And he says the purpose of section 39(1) is to confer exempt status on persons in a manner which will fulfil the underlying regulatory and protective purposes of the legislation.
Yes.
And one can see that if you have an AR which is not expert in dealing with retail customers but is expert in dealing with professional customers, it will, one might think, tend to subvert the regulatory regime somehow for, as I understand on your submission, the allocation of any business on to an AR under an AR agreement creates, in effect, a mandatory exemption in respect of the whole of that business, including for the retail customers where ex hypothesi they have no expertise in dealing with retail customers.
In our respectful submission, it's very different, in fact, the opposite, because in relation to client classification, that is part of the onboarding process, which everyone has to do in relation to the activities they carry out. And so every AR and every authorised person, if they're doing direct business, has to go through a client classification process in relation to the onboarding.
Right. If I may say so, I'm not quite sure where that takes you. That's just if they've been told don't deal with retail customers, they have to check, is this person who's walked in my door a retail customer or not? That seems to be the onboarding point, isn't it?
Because if they get that so the authorised person is trusting the appointed representative to carry out that process of classification at the outset.
Right.
And it subverts the consumer protection statutory purpose if they simply get that wrong, that puts the appointed representative in the position where they lose their exemption on a let's take a hypothetical scenario. It was an entirely innocent and non-negligent way. They are then exposed to
I think we've been told criminal liability.
Under Section 19 of the General Prohibition.
But just on that, so why does that subvert the consumer protection aspect of this? Doesn't the fact that if they get it wrong, they'll be exposed to criminal liability give them a very strong incentive to try to get it right, which is to protect consumers?
Well, they would in any event be trying to get it right. The reason why it subverts the statutory protection is because your ability then as an investor, a customer, to have a long stock liability as against the person who has the substance, the wealth, the authorised person, is lost. In circumstances where if it had been the authorised person who'd been doing that activity, so let's just assume this scenario, the authorised person has the same restriction in relation to retail client. They try and classify, and as it happens, they classify incorrectly. In those circumstances, the authorised person is not treated in breach of the general prohibition, and they also, there's still a potential claim against them by the investor. But if the authorised person asks the appointed representative to carry out that task, the investor is left with no remedy.
Yes, I see. Thank you.
And so really our point is this, is that we in terms of our understanding and the way we would say that Anderson Sense in terms of actually application on the facts, what it decided that you can, within the functional definition chosen by Parliament, subdivide, and that subdivision was said to be justifiable in part because you could have more than one principle, and so therefore you might have different types of prescribed activities of regulated activity and different product providers. But there's no steer in the statutory legislation which suggests you can do that by reference to customer types.
So let me just speak. So are you saying that what was different in Anderson was that what they were dealing with is a subclass of investments rather than a subclass of clients? And you say
yes,
part of a business of advising in investments can be advising in particular investments.
exactly.
Right.
And so,
But then initially when you were discussing it, you were saying, and in that case it was very easy to see because they had a list of the company agency investment group. But is that another criterion that has to be met? Or if the decision of whether the investment in dispute was or was not in the subclass of investments that they had defined in the agreement was a more evaluative, like high-risk investment or a low-risk investment, would that still be a subclass of investments that could comprise part of the business of advising on investments? Or does it also have to be something which is clearly demarcated?
well, it's an interesting question as to whether or not the clear demarcation test which we've articulated should be viewed as a governing part of the test, as well as simply can you view it as part of the functional subdivision, so to speak. So in the facts in Anderson and Sense, you could see that readily that didn't create a problem. I can see the point that my lady is raising, that is in other categories of case it might present more problems, in which case we would respectfully submit from the point of view of investor protection and clear legislative outcomes, it would be better to adopt a test which had a clear demarcation.
So if you said you can, in the ARA, you said you can only advise on low-risk investments, and it didn't say anything more than that, that would not be sufficient, would you say, to delineate a part of a business for the purposes of Section 39?
We would say that's too evaluative and judgmental and vague to operate as a satisfactory outcome in terms of what Parliament would have intended vis-à-vis demarcation of responsibilities. The reason why Anderson Sense on its facts could work was because to adopt the phraseology in paragraph 40, to the extent we're using the sort of what versus how, you could clearly see this was what, but in the context of client classification, at the start of every type of investment activity that you're dealing with, you have to address the question of client classification and what is this client, how are they to be treated. And that test, and my own friend, I think, sought to build a submission along the lines of, well, it's very different from the suitability test. But our simple point was this, that if you look in the relevant provisions of COBS 3, I think it's 3.5.2, and then look in COBS 9, you see the same question arises in the context of ascertaining whether or not someone is properly to be viewed as a professional elective client as a qualitative exercise which has to be performed by the AR in each case. And it makes no sense whatsoever to end up in a situation where the authorised person can turn around to the AR and say, I'm giving you this responsibility to carry out part of this process, and yet I'm not accepting the responsibility if in the way you conduct that, you get it wrong.
Well, why does that follow? Why is that an odd result?
Because
I mean, if you say to the AR, you can only deal with professional clients, why is it we don't accept responsibility beyond that? Why is it odd to impose responsibility beyond that if they get it wrong?
Because there is no easy way for the AR to avoid that exercise.
No, they've got to do the exercise.
They have to do the exercise, and the AR could easily get that exercise wrong.
Well, you say that. I mean, we've looked at the terms. They're pretty prescriptive. I mean, you'll no doubt want to take us to
yes.
them, but I mean, of course, error can be errors, but equally, so could the AP make an error. They may be, as in this very case, the AP is authorised only to deal with professional clients. So they've got to get that right, haven't they? If not, they expose themselves to regulatory and maybe civil liability.
But the consequences for both the investor and for the appointed representative are unnecessarily adverse in our respectful submission, because if the whole concept of why an AR is on the playing field is because the authorised person puts them there to do what they're doing.
Well, puts them there to do certain things.
To do certain things. And of necessity, that will involve them carrying out the activity of assessing whether or not a client is a certain type of category.
Yes.
They can't avoid that. It's not like the company agency scenario where you say, okay, there's this list and we're just not to go there. It's inherent within the onboarding process, every single case that they will have to do that. And it's inherent within the rules that it is an evaluative exercise, not a very prescriptive exercise.
But is it because it's an evaluative exercise that it's not part of it's not a severable or identifiable part of the business? Is that the reason?
Well, I think it goes back to the question of is it a sensible or logical or coherent outcome to contemplate that Parliament would have incorporated into a test which demarcated exemption for AR and responsibility, that it's to be assessed by such definitions as create a minefield? And
so it would be different if the would it be different perhaps? Would it be different if the criterion for demarcating between one client and another was absolutely clear?
Well, if you had a process which was completely separate from any evaluative exercise, similar to suitability, and if you had a process which admitted of not the adverse consequences of the AR falling into criminal liability through a very simple process.
Say you can only sell to men.
So
you can only sell to men.
So in those circumstances, you could see the force of some of the points we're making about absurdity would fall away, or lack of coherence would fall away. Because in that scenario, you would have a clear test.
Right.
So our point is that it's.
But could you lawfully exclude your responsibility by saying you can only sell to men? Forget discrimination.
Is it part of a business?
It's not.
Yes.
It's not.
Yes.
It's not.
Is it part of the business?
So going back to our original answer, then it's not part of the functional definition that you have a categorisation which incorporates the question.
But it's quite like company agencies, in the sense that it's a clearly demarcated.
I see what you're saying, yes. Well, yes, I suppose you could come up with various hypotheses, couldn't you, where you could say, okay, this is your clear demarcation test, therefore, ergo, on that hypothesis, yes.
Well, what do you...
So going back to the sort of the theme of our submissions, we would say it's not because it doesn't form part of the functional definition of prescribed business activities. But if we go beyond that and say, okay, is it a clear demarcation test? Then yes, you could. That is a clear demarcation, isn't it?
So you could carve up the business in that.
You could do.
Although you say, I think you start by saying that it's not part of the functional definition. So if it's not part of the functional definition, can you nonetheless do it? If it's clear, or
no, in our submission, it has to be. Our primary submission is it has to be. You have to be able to view it conceptually as a subdivision of arranging, or in this case, advising investments.
Okay. Well, then can we go to
page
968, which is paragraph 25 of whichever regulation it is. The regulated activities.
Yes.
And I mean that so far as the investments are concerned, it's buying, selling, etc. A particular investment, which is a security, a relevant investment, etc. A structured deposit. So you're saying, well, I mean, if you choose one or two of those, that's a part of the business. Or I mean, obviously in Anderson it wasn't that, it was who provided the securities or the products, wasn't it? Does that fell within that was a part of the functional activity?
Because you can see that in the Anderson context, can't you, that what you're alighting on is a particular subdivision of a particular investment as described in the regulations, and that's
okay.
And that's the way we rationalise Anderson's.
All right, but then paragraph 24.5.1 begins by saying making arrangements for another person.
Yes.
So making arrangements for another person, or under the advising one, which is 28, I think, advising another person. It's part of the functional activity that you're providing. You're providing the service, the promotion or advice to a person. So why can't you divide up the persons?
Well, we respectfully submit that would cause the difficulties that if you take that approach, and if you were to take that approach, we will come back to the submissions we made, which is that you then enter into all sorts of difficulties. Because,
like what? I mean, you were talking then about the difficulties of definition.
Well, both definition and also outcomes.
I see.
Can I go back to the COBS point, because I think it's probably important that we just draw this point out in terms of
yes, of course,
the relevant parts in COB just to see. So it might be useful to do this both by reference to the rules and also the relevant provisions, some of the documentary evidence we have before us. But so far as the client's position is concerned, the important point, I think, is really just to sort of focus on for present purposes is if we go to COBS, which is 987.
Sorry, 907?
987 is where COBS starts. And the part dealing with elective professional clients, it starts a bit lower down, but you can see that it starts at 3.2.3 with a definition of who is the client.
So this is on page 3, 988.
Yes. So we have COBS 3.2.3. If a firm provides services to a person that is acting as an agent, the identity of its client will be determined in accordance with all agents as clients. And then we have retail clients. A retail client is a client who is not a professional client or an eligible counterparty over the page at 3.4.1.
Sorry.
So we have who is the client. Sorry, let's go back to the general definition. 3.2.1, general definition. a person to whom a firm provides, intends to provide, or has provided a service in the course of carrying on a regulated activity is a client of that firm. Now, pausing there, the concept of regulated activity is the drumbeat, if you like, which you see throughout these provisions. But it's defined here, is it not, by reference to a person to whom a firm provides, intends to provide, or has provided a service. So it's contemplated as an exercise both prospectively while it happens and after it happens. And we see that emphasised in sub 2 by reference to a client includes a potential client. I was then going to skip on to the retail clients.
But 1.4 is important, isn't it? That the definition of the client relies on, rather than influencing, whether the firm, which is the principal, has accepted responsibility for them. So if you're not somebody for whom the principal has accepted responsibility, then you're not a client of the firm. Isn't that
Yes.
what one?
Is that right? Is it the appointed representative has accepted
The client of
responsibility?
an appointed representative.
I think that probably just takes you back, doesn't it, to the client of an appointed representative or applicable, a tied agent, acts or intends to act in the course of business for which that firm has accepted responsibility under the Act. So that takes you back, doesn't it, to acceptance of responsibility, probably under Section 39(3).
I think so.
I think so. We'll come back to that point if we think there's something further to be drawn out of that. But then we then have retail clients at 3.4, which is defined as not a professional client or an eligible counterparty. And then if we go in, sorry, that's at 3.4 at page 989. Apologies if I'm skipping over these things too quickly. But we then have professional clients at 3.5, which is at page 990. And we have per se professional clients, which we don't need to deal with to any great extent because there are clear definitions in relation to that as to who is or who isn't within that. If we then go on to elective professional clients, which is the category of clients we're dealing with here, at 3.5.3,
So you say there's no difficulty in relation to professional clients?
So what we're saying here is if you look at 3.5.31...
No, I think you accept in relation to professional clients that it's clear-cut. There's no exercise of judgment really involved in that.
Oh, sorry.
Isn't that the point? That's how I understood it.
Per se professional clients.
Oh, is it per se?
Per se.
Yes, per se. I see.
But the more important category for the vast majority of
so the per se professional clients are clearly delineated.
They're clearly delineated,
okay.
And they're typically large firms which have substantial turnover.
There's no difficulty in.
So there's no difficulty. The difficulty arises in relation to elective professional clients, which is at 3.5.3.
So if the appointed representative agreement said you can only deal with per se professional clients, would you accept that was a valid demarcation of a part of the business of advising on investment?
Not on our primary case, because it's not a definition which falls within the subdivision scheme which I explained previously. Yeah. But on our secondary case, of the question of clear demarcation, it may well be that you could say that that's an easy and clear demarcation exercise. The difficulty really arises in elective professional clients, which is this case, where everyone signed up these elective professional client forms. And inherent as part of that in 3.5.3 is a qualitative test under subsection 1. And that is a qualitative test which has much in common with the suitability tests of expertise, experience and knowledge, which we'll come on to in a few moments' time, which was the point recognised correctly by the Court of Appeal. And contrary to what my learned friends suggest in their written case, it also feeds through into the process involving eligible counterparties at 3.6, because if you go to the definition of eligible counterparties, which is at page 993, per se, again, is not so difficult, because you have what are normally very substantial institutions. Again, it's the elective element, which involves, by incorporation, an element of qualitative exercise. Because if you go to 3.6.4, you see, I think my learned friend took you to sub 1.
Sorry, which page?
Page 993. So my learned friend took you to sub 1, the client is an undertaking and is a per se professional client. But then we have little b, which I'm not sure if we looked at. So you see there's an or at the end of A, and then we have B, request such categorization and is an elective professional client. So the elective eligible counterparties incorporates by reference the concept of elective professional client, which itself also has, as we've seen a few moments ago, a qualitative test. But it goes even beyond that. If we look at COBS 9 in relation to suitability,
COBS 9.
so that's at page 997.
Right.
Sorry, bear with us a moment.
Sorry?
9.2.
9.2, that's page 997.
Yes.
So
which subparagraph are you referring to?
So I was just going to take you through, firstly, 9.2.1 sub 2. So when making the personal recommendation or managing the investments, the firm must obtain the necessary information regarding the client's knowledge and experience in the investment field. Now, financial situation investment objectives. Now, at least part of that, in effect, is the same exercise as is being carried out under 3.5.31. So if you go back to 3.5.31, it may be we can do a useful side-by-side exercise here by reference to the written case. So if we go, back to page. So if we stay with suitability at 997, and if we go to page 99, also.
Page. Sorry.
If we have the key documents file.
Yes, it is. It's paragraph 54.
54.
So you're looking in the appellant's written case.
If you look in the appellant's written case in paragraph 54 and just have that,
I see.
And have that next to COBS 9.2.12, I think you get the point.
Sorry, just let me get back to 997.
997.
Yep. So what are you wanting us to do?
So the point is that the activities which are part of the suitability test share much in common with the activities you see under client classification. They both require the authorised person or the appointed representative, whoever is carrying out this activity, to consider and evaluate the knowledge and experience of the client.
And your case is that once it's got that kind of evaluative element to it, as you say, both assessing suitability and being an elective professional client are concerned, then that means it cannot be used to demarcate a part of a business for the purposes of Section 39. And it doesn't matter whether the particular person was absolutely clearly retail or absolutely clearly professional. Everybody is then in that business which the appointed representative is permitted to do, or for which the principal accepts responsibility. It's not a sort of bespoke client-by-client person.
No,
that's right.
Exactly. And we would say that actually, whilst there may be clear cases where you can see that this is obviously wrong, that's not always the case. There will be some people who will be close to the boundary.
Right. And if there's the potential for people to be close to the borderline, then that means it's not sufficiently clear for it to be capable of being a part of the business to exclude them for your alternative way of putting your case.
Exactly. And it goes beyond that, actually, because it was a point which we haven't drawn out in our writ submissions, but we spotted in the course of preparing for this hearing, is if let's go on and look at, I think it's 9.2.8.
Just before you do, sorry. Before the short adjournment, you took us to page 290, which effectively had 3 questions that led to the categorisation of the person as an elective professional. Have you ever invested in real estate property? How many times, if so? And is property a liquid or illiquid asset class? Yes, and then there were some other questions. Those are very binary. There's not much assessment involved. If they say yes to having invested, if they understand what illiquid and liquid mean by ticking it, I mean, I just don't understand this great weight you're placing on this evaluative and judgmental assessment. If that's the questionnaire, it goes to the client.
If we go back, to 290, yes, we have the first 3 questions, don't we, which we see there. So basically what happens is there's a questionnaire which they try and use to try and gauge where this person might be positioned on the grade. But if you look over the page, we have further questions which we don't see the whole of, unfortunately, but which are to do with trying to gauge what sort of level of sophistication this person might be. It seems to be the thrust of it. And then over the page at 292, on the declaration.
Well, that's declaring that you understand the consequences.
No. It makes crystal clear. Everyone understands that this is an assessment exercise, which is not simply a tick box exercise. So if you look at the top of the 292, subject to your assessment of my expertise, experience, and knowledge of me, you're reasonably insured. So,
well, are you saying there's more that is assessed than those answers to those questions?
Yes, they won't simply be. This will be part of the exercise that they will be looking at. So part of the exercise will be looking at some onboarding questionnaires in order to try and gauge what they are. But they couldn't simply just say, okay, well, it's not. The statutory test doesn't say this is the form you use to gauge whether someone is deemed allowed to elect up or not by reference to this particular questionnaire, which then delivers your outcome in terms of this mark scheme. It's an evaluative, subjective exercise, and my learned junior, I think, will draw your attention to a couple of cases where someone has sued the authorised person for misclassification, where there is a trial on the question of whether or not they got it right or wrong. So before we leave this document section...
sorry, I took you out of
Sorry, you did
order.
take me out of turn.
Yes.
So
You wanted to go to 9.2.8?
Yes, please, 9.2.8. So this is quite an important point to understand insofar as the interconnection between these two processes are concerned. It is in 9.2.8 by reference to professional clients. It says if a firm makes a personal recommendation or manages investments for a professional client in the course of MiFID or equivalent third country business, it is entitled to assume that in relation to the products, transactions and services which the professional client is so classified, the client has the necessary level of experience and knowledge for the purposes of COBS 9.2.2r. So not only are the two processes which we see processes which have much in common and have a qualitative assessment rather than simply a quantitative exercise, but the suitability assessment test incorporates by reference the process that you've gone through in order to identify someone as a professional client. They're not just in common, they are intimately interlinked. And you see this played out in this
I
case.
think just to understand this, it would be helpful to because 9.2.8 relates to
Professional.
in the course of MiFID or equivalent third country business. So just explain to us how, very quickly, what that encompasses.
Well, my understanding is in relation to MiFID is that it's MiFID business if you had a head organisation which is in the UK or other MiFID countries.
You have a what, sorry?
Head office within.
Whose head office?
The
provider,
firm,
the advisor.
the firm. No, the firm, not the AR, the authorised
the firm.
person. So that test is focused by reference to the location of the firm.
Right. Okay. Thank you.
Sorry, I was going to move on to one further point associated with this, which is to go back to the sequence of documents so far as the assessment process is concerned. And if we go back to Appendix 7 to the compliance audit, at page 293, which I think my learned friend briefly took you to, if you look at 297, you can see that this is the section where, under the compliance audit, they're checking whether or not the AR is acting in accordance with the permissions permitted under the AR principal relationship. And you see, in effect, a cut and paste of the definition of relevant business for the purposes of assessing that. And you'll note that the comment at the end, which is to do with the CIS point, which Mr. Callan raised at a certain point in time, which features in terms of the comments in the judgments. Of course, this is the foundation stone, if you like, for the acceptance of responsibility, because what it shows is that the relevant business for which they're accepting responsibility for, by reference to the prescribed descriptions, is the arranging business and giving advice. As per the articles in the RAO, which are further defined in the Regulation 2. And in particular, you see at the end of this little section that the acknowledgement that the AR will offer advisory and arranging services to third-party investors with regard to residential property investment. Also, then the subsequent words, which we don't need to trouble you with because it doesn't form part of this appeal. But the very thing, the very activity which this AR was appointed for is what the AR was doing, subject to the question of the prohibition as regards retail clients as whether or not you could validly say that prohibition cuts down on the assumption of responsibility.
What's the relevance of that, apart from being a...
Sorry?
You say it's the very activity that they were appointed for, but does that have any influence on whether it can be a part of a business for the purposes of Section 39?
Well, it really is just to sort of illustrate that this is the complete opposite of the Anderson Sense type case. In the Anderson Sense type case, the activity which was being complained of was hidden from the principal and didn't even register on the systems in a way which could actually be monitored. But what we have here is the complete opposite. What we have here is the activities which we are saying form part of their acceptance of responsibility, were the very things which it was contemplated that they would be doing in relation to the very types of investment, if I can put it that way, it was contemplated they would be doing. And there were two other points I just wanted to raise by reference to this form as a useful way of dealing with it. There's the review of client onboarding and categorisation, and you can see those are both considered together in this document at 301 at the bottom of the page.
And this really treats them as if they were subject to COBS and is assessing their compliance with
Absolutely.
COBS, although it's not, they're not actually subject to
No, but they are, because the appointed, the authorised...
It's a sort of shorthand, really.
It's shorthand. In fact, the reference in the covering letter is also slightly wrong, as it talks about them being authorised to do things.
Or checking their compliance with regulations.
Exactly. But this is that is because inter se, as between the authorised person and the AR, they are very much wanting to ensure that they comply with COBS, because if they don't, then obviously they will potentially be in difficulty. And that enhances consumer protection. And it forms part of what they were reviewing and doing. And you can see that in the bottom of this page, the client categorisation and onboarding process stored by Kession on its internal records. If you go back to the AR, you'll see that there was relevant provision about provision information and monitoring.
Bottom of 301.
Bottom of 301,
Yes.
Findings, list of clients provided and stored in Kession's internal records. That's the principal's internal records. The AR is using onboarding and categorisation documents provided by Kession. And then over the page, we have the audit, the file reviews for various different people, including some of the respondents, for example, Mira Shah, that was one of the ones we looked at. And they review their Know Your Client and anti-money laundering work. They review their elective professional opting out letter and all the other documents.
EP is elective professional.
EP is elective professional, yeah.
And that's the questionnaire we looked at a moment
Yeah.
ago.
Right, so the auditor looked at those files, reviewed those files, and didn't see anything amiss, basically.
No, not according to this. And then we have suitability assessment. Sorry, before we go to that, we also, you see at the bottom of the page, further information about assessing what the AR has done in terms of their assessment. Speaks to every investor on their experience to gain an assessment of the investor's experience and knowledge. Can you see that? Mm-hmm. Which I think goes to the point
Does.
my lady was raising about the exercise. And then we have 303 suitability assessments. And on suitability assessments here we see client suitability, COBS 9. Suitability advice must be assessed in accordance with the following criteria. And then we have 1, knowledge and experience in investment.
Sorry, where are you reading?
Sorry, I'm over page 303, did I not say? 303 under the heading suitability assessments.
on 303 itself.
Yeah.
Yes, so halfway
Yes,
down,
got it. Yes, got it.
near the bottom of the
Got it,
page.
yes.
My apologies if I'm going too
Not
quickly.
good, not
Suitability assessments, client suitability advisors, discretionary managers only. And then we have knowledge and experience in the investment field relevant to the specific type of designated investment or service. In brackets, presumed for elected professionals and per se. So we can see that the rules we've just been taking this court to are reflected in the documents in relation to the process carried out. And that emphasises that well, perhaps to borrow a phrase from another case, Tenet Connect, it's braided. This is a braided process. So how do we end up in a situation where in cases like Tenet Connect, we have where there's braided advice between regulated and unregulated, or in cases like Adams and Options, which a lady was involved in, where there's sort of what is and what is outside the perimeter. The general approach the courts take in those cases is to treat braided situations as situations which should be covered by regulation and by protection.
Sorry, I don't know the term braided.
So it's a phrase which comes from Tenet Connect is the
Right.
case.
But I don't know what it means.
Nor do I.
Well, it's dealing with a situation where you may be involved in advising on someone to sell a regulated product and buy an unregulated product.
Right.
And in advising on whether or not you should buy or sell, the courts take the view that in relation to that, because it's all part of one exercise, it should be viewed as braided, and therefore the advice on the unregulated aspect should be viewed as advice on the regulated aspect.
Oh, I see. Yes, I think so. So if you're selling a regulated product to buy an unregulated, or vice versa, because they're all in effect part of one transaction.
Interconnected, interlinked.
Right. So how does that help us here?
Because if we have a recognition and establishment in the context of those cases that where something is interlinked, it makes sense for it to form part of the regulatory sphere, even if you might argue it's outside. Here we have an activity where it's accepted on my learned friend's side, suitability, it forms part of the how, not the what, but apparently client classification.
I've come back to my point. Suitability. To say you can't really say that you've got a business of making suitable suggestions and another business of making unsuitable suggestions. That really just makes no sense at all.
That's a slightly different point, if I might say so.
Right.
The point we're trying to get at is it's accepted. My learned friend accepts lines have to be drawn. Part of can't mean everything. Cool. And so in relation to the question of the forensic inquiry of what part of is, he accepts on his side, well, suitability assessment, for example, could be treated as part of that. But here we have a situation where he says is to be treated as a what rather than the how. But the what exercise forms also part of the how exercise in his case. It's an interlinked exercise. So in our respectful submission, it makes no sense to end up in a conclusion that Parliament intended that this type of activity could be used to control exemption and responsibility in circumstances where it's so tied up with a process that everyone recognises can't be treated as part of what on the Anderson sense terms. But if we're wrong about that, then my lordship's part of your lordship's reasoning in an Anderson sense, which is that it will be a rare case where this problem arises, is
something you used to regret something.
Well, on our rationalisation, my lord, there was no need for us to challenge the correctness of Anderson's sense in the Court of Appeal. But I obviously made the submission to your lordship. Well, this will cause problems. Your lordship rejected it. Said no. There's an ability to make a clear demarcation here, and think you can do it. But if in fact the outcome is we end up in this situation where part of the governing test is by reference to these sorts of subjective evaluative concepts which bleed across into concepts which are accepted as being part of the how, that simply doesn't make sense. And our primary position, of course, is that they're reconcilable. But we would not want to end up in a situation where my ladies and your lords concludes, well, because you didn't argue against that proposition in some way, that we're in a worse position, if I can put it that way. So we positively say they can be reconciled in that way, and the way you reconcile it is you say, as all three judges in the Court of Appeal recognise, that the process of client categorisation is how you conduct the business. It forms part of COBS. COBS is how, and Lord Justice Lewison was only a dissent on this point, not for this reason, but for a different reason which I don't understand my learned friend to be seeking to uphold in his oral argument. I should probably...
I'm sorry, but I sort of had the impression it formed a significant part of his argument this morning.
Well, in which case I should briefly deal with it, but shall I just go briefly to section 19 and 20 and 31 then, just to briefly deal with this point?
Right.
Sorry, you're going to...
to deal with the dissent.
Yes.
Because
you said you were going to section 19?
Yes, so yes, of the Act, yes.
Right.
So if we can go to that section of the Act which 899, I'm told, is the relevant.
Thank you.
So if we start with section 19, the general prohibition, no person may carry on a regulated activity in the UK or purport to do so unless he is an authorised person or an exempt person. So those are the two types of people who are entitled to carry on regulated activity, and that prohibition is referred to the general prohibition. As you will be aware, contravention of that is a criminal offence under section 23. But before we go on to section 23, if we go to section 20, we have a section headed authorised persons acting without permission, and this is at page 900. So the important points to pick out of section 20 are it's dealing with authorised persons acting without permission. If you want the introduction of the concept of authorised persons, you get that from section 31, which is, if you want to turn to that at page 909, is defined by reference to person who has apart for a permission to carry on one or more regulated activities. So the situation is that you become an authorised person if you have just one or more regulated activity permissions. We go then back to section 20 and deal with the situation of the authorised persons acting without permission. So this is the situation where an authorised person is carrying on regulated activity or purports to do so, but otherwise than in accordance with their permission. And you can see at the tail note of little 1, if they do so, they are taken to have contravened a requirement imposed on them by the FCA under the Act. But you can see from little 2, a contravention within subsection 1 does not, except as subject to certain exceptions which are not applicable here, make a person guilty of an offence. So just to sort of square the circle with those submissions, The outcome is that in relation to an authorised person, they maintain their status as an authorised person for the purposes of the Act, even if they are acting in an area outside their permission. So their status as an authorised person is not circumscribed by reference to whether or not they're acting within the perimeter, if I can put it that way.
And you think that Lord Justice Lewison misunderstood that?
Yes. And if we go to the specific part of the judgment which we respectfully submit shows that to be so, his judgment starts at page 132. The key documents bundle. Is it what?
194.
194 in the main bundle. And you may just want to briefly cast your eye over the relevant paragraphs, but we say where the reasoning starts to go wrong is in paragraph 100. In fairness to my Lord Justice Lewison, this point was raised by the court, this question of the authorisation.
So yes, you quarrel in particular, is this right? With what is said in paragraph 100.
Yes, it just goes wrong with this, even with the first sentence. Is not an authorised person except he's carrying on of regulated activities is authorised by the FCA. That's not how it works.
But, can one see... I rather read Lord Justice Lewison as making perhaps the point that I understood Mr. Houth to be making this morning, which one can get from paragraph 103, for example.
I think 103...
does not overcome what I regard as the fundamental point that KCL was not authorised to advise such clients. Now,
yes.
The fact that it continues to have the status of authorised person and therefore does not commit a criminal offence does not necessarily undermine, does it, what Lord Justice Lewison was saying in paragraph 103?
Well, I think if once you get to 103, you've got 100, which is basically suggesting that an AR who purports to enter into an agreement in relation to an area which they're not authorised to carry on can't be treated as an authorised person. So he's functioning on almost like a capacity type argument there. But that's just simply wrong, because an authorised person remains an authorised person as long as they have just one permission.
Yes, but
it's not really the point he's making.
I don't think it is.
102, isn't it?
Well, if you look at 102 then, which is the sort of the next point, by reason of he says, I regard the exclusion of retail clients as falling on the what rather than I do not think that for this purpose it matters the regulators, as is described in general and generic terms in the AR regulations. Specifically permits contract to cover this only part. On the face of it, it seems to me that KCL was not an authorised person. So that, you
say, is the same error as he makes in paragraph 100.
Exactly. It's the key part of his reasoning. It's the same error at the end of paragraph 102.
I rather took him to be making the point. I understand the point that you're making, but I understood the thrust of the point that he was making to be that if Parliament has authorised the FCA to specify particular categories of conduct as being capable of being specified in the permission, why does it seem odd or peculiar that when construing section 39(1)(b) and the reference to part of the business there, that one could imagine that an ARA could draw the line in precisely the same place.
Well, I certainly read the judgment as very much leaning in on the question of capacity of authorised person, and
right. All right. Well, let me ask. So, Pace is not making that point. Let me ask you
just to deal with that point.
Yeah.
In our respectful submission, in circumstances when the legislature has provided that an authorised person is to be treated as authorised if they have just one permission. So if they just have one permission, they are an authorised person. If they act outside that area of their activity, they're not treated as being in contravention of the general prohibition.
No, but they're treated as being in breach of the regulatory standard.
Well, they would be in breach of their yes, of course, they'd be in breach of their permissions.
Right.
But they wouldn't be in breach of the general prohibition. They wouldn't be subject to a criminal offence.
Right, but the point that I'm putting to you,
yeah,
which I did rather understand Lord Justice Lewison to be making, is does that not show that the legislature has contemplated that one can sensibly draw dividing lines within the overall scope of an authorised person's business, which carves it up in a way which has regulatory consequences, because if you fall on the wrong side of your authorisation, you fall outside your authorisation, you're going to be caught in unpleasant regulatory consequences. And the line is drawn or can be drawn in terms of retail, non-retail business.
Well, no, because we can see that Parliament decided not simply to put the AR in the equivalent position of the authorised person. They're in a different position because they're treated as exempt, and the guide that the Parliament has chosen vis-à-vis the exemption and the assumption of responsibility is by reference to the prescribed activities which we've seen identified. And if you go back to the earlier legislation, for example, the Financial Services Act 1986, there is no concept of a restriction in relation to of the type that my learned friend has suggested was brought in under Section 55E. I've had limited time to deal with this.
So you can't go back to that Act because that Act only dealt with one small part of what's dealt with in FSMA. FSMA was a complete redrawing of the regulatory landscape, not just for financial services, but for insurance and banking as well. So I don't see that you can go back to the 1986 Act from the 2000 Act.
Well, we thought it was reasonable to go back to the 1986 Act because Section 44, which then becomes Section 39, it is typically viewed as being materially the same in terms of its approach. And that exercise, which seeks to capture the concept of investment business rather than regulated activities, doesn't incorporate any of the same restrictions which we're looking at here. But moreover, so far as we're aware, my learned friend can correct us if I'm wrong, but no one has adduced any evidence before the court or showed the regulation which suggests that a client classification restriction was something which the FSA had in contemplation as a restriction on the licence as at the date when the...
Well, is there any list anywhere, just a quick question, yes, is there any list anywhere or guidance from the FCA as to the kinds of restrictions or limitations that they impose under Section 55E? Is there something in the bundle or something we could be shown as to the kinds of limitations?
We've seen the explanatory notes that refer
yes, but
to
what do they actually... What do they actually...
Yeah, well, if we just look at the rules in SUP, just to make this may draw this point out. Sorry, I'm out of time, I think, for the purposes of...
Sorry.
I'm out of time, I think, probably for the purposes of my submissions, but I was just going to draw your attention to a distinction between the concept of regulatory activities and limitations or requirements on permissions, if I can put it that way. So the distinction between the two. And we draw your attention to the contrasting language used in
Are there page numbers for this?
Yes, so it's SUP 12.5.3G at page 110, and then SUP 12.611 AR at page 1015.
1015.
So 110 and 1015.
110. I think
1010.
1010.
Sorry.
Yeah,
Can you give us the
1010 and
1010
1015.
and 1015.
Well, Mr. Sims, I'm afraid
Yes.
we have to conclude.
I was going to give my learned junior an opportunity to say a few words, but I'm afraid I've probably taken up the
afraid you've
time. So
taken
can I just
up the
check
time.
whether there's
I
anything
don't
that
know
I've...
if Mr. Chigese wants to, in 1 minute, to direct us to the authorities that he was going to refer to,
Or the part of the printed case.
or the part of the case, indeed.
I'm grateful, thank you. I'll be quite quick.
you need to come closer to the microphone so,
Yes, of
people
course, yeah.
online can hear you.
I'll just conclude by way of coherence and in terms of the scheme. We've seen through Section 19 in the General Prohibition, we've seen through Section 20 that the approach to a principle in these circumstances is very different to the approach that would be taken to an appointed representative. On our construction, we say that coherence is achieved within the regulatory scheme, because if a principal was engaging in business directly out with a limitation within its permission, there would be consequences that could potentially follow, regulatory consequences, fining, censure, potentially suspension, potentially withdrawal of the permission. We say that the same circumstances on our construction operate through the mechanism of a contract and through the appointed representative regime, because what happens on our construction is the AR doesn't lose exemption, isn't exposed to potential criminal liability in the same way that you can achieve coherence with the principle in those circumstances. But the contract itself operates through inter se provisions, rights, indemnities in this case, and the termination provisions. And in fact, under the regulatory scheme, in circumstances, and you'll see this through SUP, we've referred to it in our written case, within the regulatory scheme, the principal is obliged in certain circumstances to terminate the AR contract. And a classical situation where it would terminate the contract is where its appointed representative was acting beyond the limitations that were imposed within the principal's own permission. So we say we achieve coherence, we avoid the absurdity that we say follows from their construction. We've alighted to that absurdity in our written case. I don't have time to take you through all of that absurdity, but my learned leader has dealt with most of it.
And just in your printed case, where do you deal with it? Just to give us the paragraph number, not to develop it.
74, isn't it? 74.
I'm told by my learned leader it's at paragraph 74.
74. Thank you very much.
Section starting.
And it's starting on page 36.
Yes.
And we cite principles which this court will be.
Thank you, Mr. Chigese. We're grateful to you. I'm sorry that you weren't allowed to address us at greater length. Mr. Howarth.
My lords, my ladies, I'll try to be as quick as I can. In relation, taking it as it were backwards in the order in which we've just heard submissions, I don't want to say anything about the dissenting judgment of Lord Justice Lewison, because various comments from the court have dealt with what I wanted to say, namely the gist of what he was thinking about was clear. If you haven't got the permission, it looks very odd that you can pass it on to someone else, and that is, in my submission, the fair reading of his brief judgment. Lords, the ladies, we also respectfully adopt a remark made by Lord Richards to the effect that if one looks at the definitions, insofar as they include the words providing services, quote, for another person, then the other person is, as it were, part of the category. So why should it not be that one can differentiate effectively, for the purposes of cutting down the commission, between retail clients and other types of clients. It was suggested by learned friend Mr. Sims that all this was dangerous for the appointed representative if much turned upon the classification, because it was said he could be exposed to criminal sanctions. And there are 2 points about that. The first is the one Lord Sales put to him, which was, well, doesn't that incentivise the appointed representative to take care? But there's an allied point, which is that if the appointed representative is unsure, as we have seen, the default category is retail client. And that makes sense in terms of consumer protection, because it's the retail client who gets the benefit, for example, of COBS 9. And in general terms, quite a lot of this is in our written case, and I tried not to repeat it, but we take the position that the words whole and part of are clear, and their meaning as a matter of ordinary English is clear. The point was put to my learned friend by Lord Sales that, well, doesn't that show that Parliament was contemplating that the business might be carved up in any manner of ways, with which we agree, and we say as long as it is clear, as long as it goes to what you can do, then it is effective. Before the short adjournment, my learned friend Mr. Sims said, well, categorisation is tricky. It's an easy mistake to make. There are 2 points about that. One, we do not know here how a mistake was made, assuming that it was. We've seen some of the paperwork, not all of it. So it doesn't follow at all that this is a tricky process, and Lady Simler made some points about that. I have got, as it were, one piece of information for the court, or the penultimate point. I was asked, I think, by Lady Rose before the short adjournment, whether there were any particular qualifications that had to be held to advise a retail client. Certainly, that question was put to me, and I said I'd try to find out. There is a training and competence sourcebook. I haven't got a copy of that, I'm afraid. I've had to make inquiries without getting copies. That applies only in relation to retail clients.
Its title again?
Sorry?
Its title, once again?
Training and Competence Sourcebook.
Thank you.
It will have an abbreviation, but I don't know precisely what that is at the moment.
Sure, it will, like everything else in this case.
Absolutely, yes. It only applies to persons who are going to advise retail clients. It does not contain any specific requirement. So it doesn't say you have to have such and such a diploma in advising retail clients. I'm given to understand that the reason behind this is that first of all, competence is treated as an overriding objective within this sourcebook by the FCA, and therefore is not the subject of prescriptive rules, so that they can look at each case on a case-by-case basis, so to speak. There are courses that people can take which give them a qualification in connection with being able to advise a retail client. And it seems to us, and we submit, that even though this competence sourcebook is not prescriptive in that you have to have such and such a badge, as it were, one can imagine that if the FCA investigated and said, well, how are you sure these people are competent? It would be of great assistance to be able to say, well, they've passed these courses, and equally, one would not be assisted if one said, well, we had a chat with him and he seemed quite a good chap and seemed to know what he was doing. That probably wouldn't do. So, my lords and my ladies, we end really with what we say is one of the curiosities about the way in which my learned friends put it, which has been explored this afternoon. But what it boils down to on their submission is that it is perfectly valid as a what restriction for someone to say, I'm going to restrict those with whom you are doing business, i.e. persons having a company, agency, so on and so forth. But it is completely wrong to say, I am going, or completely ineffective, I should say, to say, I am going to restrict with whom you do the business, whom you assign.
Sorry, I didn't... The contrast, you say, is between being valid to have a what restriction as to...
As to the provider of the product.
As to the provider. Right, thank you.
But it's not, apparently, so my learned friends say, a valid restriction to restrict the AR by virtue of to whom you should give the advice. And we say that can't be right. My lords, my ladies, I have about 60 seconds left. There is nothing else I wish to say.
Can I ask you the question? Is there anywhere some information about what kinds of limitations or permissions are set by the FCA pursuant to section 55E?
Lady, I do not know as I stand here now. We could seek to make inquiries and let the court know.
Well, I think it's part of your case that they can, if it's a kind of permission a kind of limitation on permission that the FCA can place on an authorisation,
yes,
then it ought to be the kind of demarcation line between a part of a business and a non-part of a business in the ARA.
yes.
So I think it might be helpful for us to have a look at what kinds of limitations on permission we're talking about.
Indeed, my lady, we'll make inquiries and we'll advise the court as soon as possible. And there will be, as it were, a nil return. If we cannot find anything that we think will be helpful, we will let you know that too.
Thank you very much. Thank you. Well, we're very grateful to all counsel in the case for your written and oral submissions. Also very grateful to those sitting behind you for the preparation of the case. And clearly it's an important matter. We will take time to consider our decision, which we will deliver in due course. Thank you all very much. The court is now adjourned.